I'm Drew Stevenson, and this is a lecture for my professional responsibility class about significantly harmful information and obligations to prospective clients. Sometimes someone comes in for a consultation, or maybe you have a telephone consultation or emails, and they share information, but you decide either not to represent them or they don't hire you to represent them, and you still have some ongoing duties. Now, the ABA put out an ethics opinion, a formal ethics opinion in June of 2020, number 492, which they called Obligations to Prospective Clients, Confidentiality, Conflicts, and Significantly Harmful Information. It's really all about what counts as significantly harmful information and a lawyer's duty to keep that confidential. And so I'm covering this, even though we covered Rule 1.18 under conflicts, this is really more of a confidentiality issue. So what's a prospective client? It's someone who comes in or calls you and consults with the lawyer just about possibly forming a client-lawyer relationship. And Model Rule 1.18, just to remind you, governs whether such a consultation limits the lawyer or the lawyer's firm from accepting other new clients. And Rule 1.18 prohibits accepting a new matter if the lawyer received information from a prospective client that could be significantly harmful to them in the new matter. And notice that that phrase, significantly harmful, is not in Model Rule 1.9. 1.9 is about conflicts of interest with former clients, and part of the concern in that rule is confidential information. So there's some sense in which 1.18 and 1.9 overlap. But 1.18 has this phrase that the other rule doesn't, significantly harmful information, which essentially narrows the scope of the rule and gives the lawyer a little bit more freedom. So let's move on. This ethics opinion sets out what might be counted as significantly harmful, and it begins by giving factors that you should consider. The duration of the discussion. Was this a 3-minute conversation, or did you talk for hours or on multiple occasions? The topics discussed. Did you talk about the client's sensitive information, or were they just asking questions about you and your law firm and your fees? Whether the lawyer reviewed documents or financial statements. That's very important. And if you review documents, then you have significantly harmful information. Whether the information conveyed is known to other parties. If it's already known, then it's not significantly harmful. And the relationship between the information and issues in a subsequent matter. Now, there's a couple situations where there's no duty, and that this ethics opinion clarified. And at this point, from here on out, I'm going to hit some highlights that I think could show up as test questions on the MPRE. And so the one situation where you wouldn't have a duty is unsolicited or unilateral transmission of information to a lawyer, right? So you open your email one day and there's an email from somebody you've never heard of saying, I don't know if you would be willing to represent me, but here's my story. And they share a whole bunch of confidential information with you. Well, you can turn right around and represent another party in that situation. You didn't agree to meet with them. You didn't ask them to contact you or to send that information. They sent it to you unsolicited, so you have no duty. Also, we have the sort of bad faith actor who contacts a lawyer with the intent to disqualify the lawyer from representing other parties in the matter. If somebody does that, then you can still go ahead and represent other parties in the matter. There are stories, this isn't that common, but of people who anticipate litigation in the future, so they meet with all the firms in town that handle that kind of law, or the best firms in town, and do a consultation, and then only hire one, but they're hoping that the other firms will be unavailable, therefore, because of a conflict, because of that consultation, to the other party, and they'll make it harder for the other side to find a lawyer. They'll have to look far and wide. Well, that's acting in bad faith, and so there would be no duty in that case. So here's some examples of things that ethics boards and courts have found to be significantly harmful information. Views on settlement issues, including price or the timing of anticipated settlement. How big of a hurry is the person in? Information relating to civil or criminal liability, personal recounting of relevant events, or the prospective client's strategic thinking about how to manage the situation. Why did they do what they did? Were they hoping to cause less harm or prevent harm, or were they really trying to cause more harm? Here's a couple other examples. A 20-minute phone call that outlines potential claims against the other party and the amount needed to settle, or a presentation by a prospective corporate client about underlying facts and legal theories of its proposed lawsuit. Obviously, sensitive personal information in a divorce case is going to count. A prospective client's financial data or specifics, if you review that, that's significantly harmful information. Or let's say a prospective client that's a corporation contacts you and has some meetings and discusses possible terms and how to structure a proposed bid to acquire another corporation. All of those would count as significantly harmful information as well. Now, this ethics opinion also gives some guidance or best practices, and from the standpoint of test questions, these are things that are permissible or proper for a lawyer to do. So it's okay and a good idea to warn prospective clients against disclosing details during an initial consultation. Just start with saying, we're just here to decide whether I'm going to represent you or you want to hire us. So don't give a lot of details here that you wouldn't want other people to know about. And in fact, you can limit initial consultations to just the information absolutely necessary for deciding whether to undertake a new matter. Now, that's already spelled out in comment 4 to Rule 1.18, but I think this ethics opinion makes it a little clearer. And the second point here is take charge of the conversation. Instead of having a client come in for a consultation and say, hey, tell me your story, maybe you should have a list. Say, I have some questions for you, and kind of go down your list and confine the conversation to what you need to know to screen for conflicts or decide if this is the side you want to represent. And then you have avoided open-ended questions where they have shared confidential information. Now, what about consent? I could see this being a tricky test question. You can condition a consultation with a prospective client on informed consent that the consultation will not prevent a lawyer from representing a different client in the matter. Now, operative word here is informed. This is also in comment 5 to Rule 1.18, but it is proper if someone says, I would like to consult with you about representing me, to say, I might represent someone else in the matter, and so before I agree to meet with you, I would like you to consent that I would have your permission to do that if I decide not to represent you or you decide not to hire me. And similarly, the client can consent to you using the information. Now, how are those different? One is essentially a waiver of conflicts of interest, saying, I don't care if you represent another client in the matter. But even if you're allowed to do that, if it's different, you're not automatically authorized to disclose confidential information from the consultation just because they've waived or consented to you representing someone else. So the authorization to disclose confidential information, to use that information, is a separate consent and must be express, right? They have to expressly say, you can use any information from this initial conversation if you end up representing someone else in the matter. Here's a review question to see if you've been paying attention. During an initial consultation with a prospective client, an attorney reviews some of the person's documents and financial statements, but the person decides not to hire the attorney. May the attorney later agree to represent another party in the matter? A, yes, because the person decided not to hire the attorney, so it's their fault. Or B, no, because the attorney reviewed the documents. They have significantly harmful information. Hopefully you know the answer to that. If not, you should probably rewatch this video. And that concludes our lecture about significantly harmful information and the lawyer's duties to prospective clients or past possible clients that you didn't end up representing.